SJC-11814, Commonwealth v. Olivet Rodriguez.
Mr. Calcagni, you may begin.
May it please the Court. Your Honors, my name is Attorney John Calcagni, and it's my pleasure to be here today on behalf of Ms. Olivet Rodriguez. I'd like to start off my remarks with what I believe to be an accurate statement of the law. The Fourth Amendment to the United States Constitution and Article 14 of the Massachusetts Declaration of Rights prohibit motor vehicle stops to investigate suspected civil infractions.
Oh, they do?
That's my understanding of the law.
Motor vehicle infractions?
Well, Your Honor, motor vehicle infractions are an exception because of an
constitutional exception?
No, statutory exception.
Well, how can a statute be an exception to the Constitution?
Well, if you look at the statutory history behind these motor vehicle exceptions, there has been clear balancing of rights between the state's rights to regulate public safety in the roadways and an individual's rights to be free from intrusions. And in those limited circumstances, statutory authority has been created to allow officers to stop vehicles for observed and known motor vehicle infractions.
Let me ask you this. Someone is smoking a joint, walking through the Boston Common. The police officer smells the marijuana and wants to find out who he is and issue him his citation. The individual doesn't really want that and so starts to walk away quickly. Can the officer stop him and say, whoa, 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 stop right there. I want you are illegally possessing marijuana. I want to write you a citation.
Your Honor,
or no?
Your Honor, I think the hypothetical you provided me are markedly different from the facts of Ms. Rodriguez's case.
How come?
Because in your instance, the officer in the Boston Common would first have to smell the odor of marijuana, and then he would have to follow up with further investigation to determine if, in fact, that person was smoking marijuana by then visualizing the individual, getting closer to them to see if, in fact, they have an object in their hand that he or she is smoking, and through further investigation would confirm observation and know for certain that that individual was smoking marijuana. And then maybe does he have authority to issue the citation.
So he can't stop him. He can seize him. He can seize him.
Well, let's back this up if we could. First and foremost, the statutory construction in the decriminalization statute does not seem to provide any explicit authority to detain anybody to issue this citation.
But how can you issue a citation if you can't stop someone and issue the citation? Do you chase them down and throw it at them?
If we're talking about citations in a general sense, you raise a very interesting and practical point. However, that would be a matter for the legislature to take up, just as they've done with motor vehicle infractions. And they specifically said that when an officer observes a motor vehicle infraction, then and only then can they go ahead and stop the car.
Where does it say that? I'm sorry, I'm missing something here. Where does it say that?
Your Honor, I turn your attention to Chapter 90, Section 3, and it specifically says, if an officer observes the occurrence of a civil motor vehicle infraction, which is much different than suspecting that one be committed.
Yes, what can an officer do if he observes?
If the officer observes a motor vehicle infraction, the officer can then go ahead and stop the vehicle.
Is that what it says?
It says the officer can go ahead and issue a citation.
Right, so of course he can, but he's got to stop the vehicle to issue the citation.
But there's a distinction, Your Honor. When it comes to motor vehicle violations, they're black and white. Place yourself in the shoes of a police officer. You see the car go through the red light. You see it run the stop sign. You see the tail light out. You don't suspect that maybe the tail light's out, and that's the distinction.
If I'm a police officer and I'm driving next to your car and your window is open and poof, there's marijuana smoke coming out of it, That's not enough to say, I think there's a civil violation here. You've got to somehow actually physically see the marijuana before you can
2 points.
issue the citation?
2 points. First, bringing you back to my point a moment ago, the statutory scheme with regard to the marijuana doesn't seem to authorize a stop.
It authorizes, it authorizes citations under what? Chapter 40, Section 21D, which is the...
But if Your Honor, just bear with me 1 sec. Okay. Unlike the motor vehicle stuff, it doesn't specifically authorize. But I'll take your hypothetical a step further. You're driving next to me. You look over. You see my window down. You see a smoking implement in my hand. I'm the only one in the car blowing smoke, and you smell marijuana. That might be enough. Again, a different set of circumstances than Ms. Rodriguez's case, where the officer simply says he smells marijuana. He doesn't say he sees it coming from the particular car.
So if the officer sees a civil violation, he can seize you, but he can't investigate a civil violation by seizing you, even if he has probable cause to believe that you're committing the civil violation.
Well, the term probable cause, like the term reasonable suspicion, as this court knows from its own language in Cruz, ties back to criminal conduct, not civil conduct. So I don't even think...
I'm not talking about searches here, by the way. I mean, you confuse searches all the time. I agree with you that it may not give you the right to search the motor vehicle if you smell marijuana, even if you see the driver smoking a blunt.
Understood.
I agree with you. That's clear under our case law now.
And Your Honor, I don't confuse the difference between searches and seizures, but the legal principles that govern them are the same. We're still dealing with the Constitution. We're still dealing on a person's rights to be free from intrusion. So whether you're stopping a vehicle or asking someone to step from their vehicle or searching their person,
hugely different things, and you know they're hugely different things. Asking someone to step from the vehicle versus stopping them and issuing a citation.
But, Your Honor, I take you back to the point. In order to issue the citation, there needs to be some authority. And we have authority in the Commonwealth with regard to motor vehicle infractions. There is no express authority anywhere that my research has turned up that suggests that police can then go about stopping people to issue these marijuana citations. And again, I point to the factual distinctions between your hypotheticals and the facts of this particular case, where the officer suspected the violation. And that is markedly different than knowing the violation has occurred, as we see often with the motor vehicle cases and those matters cited by the Commonwealth.
Could I just ask you a question that doesn't really have anything directly to do with that? I could not figure out this plain view issue, how the police knew that there were pills, I don't know what kind of pills they were in this bag. How did that happen?
Well, Your Honor, I will address that very briefly. The motor vehicle, if I'm sure Your Honor's read the briefs, and as you can see here, the police were looking to stop this car. The officer that stopped it was told, hey, find probable cause and just stop it.
I know. I'm just trying to figure out how we got from the stop based on the smell of marijuana to the discovery of the pills on the back seat.
Sure.
In a bag.
Understood. That particular issue, I will tell you, Your Honor, is the subject of a pending additional motion to suppress, which hasn't been litigated. The record in this case didn't present any evidence on that issue, because at the suppression hearing, the Commonwealth simply called one officer, which was the particular officer that conducted the motor vehicle stop. Once the stop had occurred, a number of other officers arrived on scene, and as they approached the vehicle from both sides, they claimed to have seen a small package on the backseat passenger seat in between Ms. Rodriguez and another passenger, and pretty much said, hand that to me. And that's when Ms. Rodriguez handed the bag that was on the seat. And therein lies the discovery.
So why wasn't that part of this motion?
It wasn't raised below. It was raised in a second motion. There was some issues.
I know. I'm just saying, was there some kind of strategic reason why the two issues weren't raised together?
I think it was a consideration of both strategy and logistics. some of the other officers weren't available on that particular day, so it was something that the district attorney and I had decided would be addressed at a later date, depending upon how the marijuana issue resolved itself. In both, well, this particular case has currently stayed at the district court level so that that issue can be addressed depending upon the outcome of this appeal.
Can I ask you a slightly different question, taking it off of marijuana, but following up on what Justice Cordy was asking? Suppose it was that I see the driver, I'm a police officer driving next to a car, and I see the driver lifting up a Heineken bottle and drinking from it. Now, there's a law, I think, that you're not supposed to have open bottles of alcohol in a car. I think it's just a civil violation. But there is a concern, is there not, that the driver is also getting himself or herself intoxicated?
Sure. Can I address that in 2
Please.
points? First, I want to thank you for using the Heineken example, because by you saying Heineken, you're basically telling us all here that you see that green bottle with that well-known home label Heineken on it. And if you're that police officer, you now know that there's a civil infraction ongoing because of the open container. So you know it. You don't suspect it. You know it. With regard to the intoxication issue, I turn back to the court to its language in the Daniels case, where this issue is discussed, whether it be marijuana in the operation of a motor vehicle or consumption of alcohol in the operation of a motor vehicle, neither of which are illegal. It's the impairment to operate from the effects of the intoxicating substance that become the issue.
Daniel again is a search case. It's a search case, not a stop case.
Understood. This is a case of first impression, Your Honor.
There is a statute that says that it is under the motor vehicle scheme under Chapter 90. I think it's 24I, that makes it illegal to have an open alcohol container in the car. Has the statute been amended at all to suggest that it is a motor vehicle violation to have an open bag of marijuana in the car?
Or perhaps a lit marijuana cigarette.
Or anything like that?
Not to my knowledge.
So it's, I'm just trying to remember, is it illegal to have the open container in the car?
Yes.
It's not a civil infraction, it's a crime?
It's a motor vehicle civil infraction. It's under Chapter 90.
And I would argue to the court that if that can be confirmed and it's observed by the officer, opposed to being suspected, under Chapter 90, Section 3, if the officer observes, they can then go ahead and issue the citation.
So is the distinction here that the officer merely suspected that it was marijuana and didn't know? I mean, if the evidence was that he did know that it was marijuana, are you saying that in that case the stop would be appropriate, but it was not appropriate in this case only because he suspected that it was marijuana?
I am saying that, but I'm also suggesting that if the court was to conclude that if the officer knew that it was marijuana, that he should then be able to effectuate the stop. My suggesting to the court is that in the decriminalization statute and anywhere else that I've looked and researched, there's no other express authority that allows the stop to occur. So I think you raised 2 points, Justice Hines. First being whether it's suspected or observed, because that's where we get into the constitutional piece, using the corollary, the motor vehicle infraction. Where an officer observes the infraction, boom, he's allowed to make that stop.
So in Justice Link's example, if he had seen a lit marijuana cigarette, that would be different from what happened here, which was just smelling it from a passing car. Is that the distinction you're making?
Yes, Your Honor. It has to be the distinction because, again, in order for the police to intrude upon our right to be free from stops or searches, however we want to look at it, there needs to be grounds. And the line in the sand is usually reasonable suspicion for criminal activity or probable cause of criminal activity. But in this case, where it's a suspicion of consumption of marijuana, which is now a civil offense, I don't think constitutionally the officer had the authority to conduct the stop.
I want to make sure I understand what you're saying. Do you agree that if the officer had seen the defendant with what was ostensibly a marijuana cigarette and could smell the marijuana smoke as the car drove by, that officer then had the authority to direct the person to stop the car so that he could issue him a citation?
Yes. I think that...
And what's the source of that authority?
I think that it needs to be carved out and placed under the motor vehicle authority. It doesn't exist. That's my backup argument, Justice Mina, is that it doesn't exist. There's no specific authority to stop the vehicle to issue the citation. The only ones that are on the books that I'm aware of are the motor vehicle.
But he could you agree also that under similar circumstances he could stop a pedestrian that had was smoking a marijuana cigarette as he walked by the officer?
Well, with further follow-up and investigation, I think the pedestrian situation is different. People have a greater expectation of privacy in their automobile as they do opposed to walking down the road.
Can I ask you, does it make a difference that this was a driver versus a passenger? I mean, if the police officer observes driving by, sitting next to a car, where it's the passenger who's smoking the marijuana that he can smell, and it looks like a blunt, and so he can observe it and sees it, but it's the passenger rather than the driver. Does that make any difference in the analysis?
I would say no. Everyone is entitled to the same protection of the law. So if that vehicle is being stopped because of somebody else in the car, everybody else in the vehicle's rights are being violated. So I would say I don't think it changes the analysis. I'm about out of time.
You're out of time. But does it matter that this stop was not for the purpose of making a motor vehicle?
I do. I think it does matter, and I was going to ask for leave just to make a final comment. I noticed in the recent Sheridan decision, the court used some language that really struck me, and it said that in the Sheridan case, they weren't going to permit the police conduct there because they didn't want to create a tool for law enforcement to search for evidence of criminal activity that was otherwise in the absence of probable cause. And Chief Justice Gantz, that's exactly what happened in Ms. Rodriguez's case. The Commonwealth concedes they didn't have probable cause or reasonable suspicion of criminal activity. There was a takedown order to stop that car, and the police officers hung their hat on suspicion of a civil infraction. And I don't believe the Constitution allows it, and that's why we came here today. And we thank you for your time.
Thank you.
Mr. Chief Justice, may it please the Court, Corey Maston for the Commonwealth. Because the procedural provision governing the issuance of civil marijuana citations directs the enforcing person, if possible, to deliver the notice to the violator at the time and place of the violation, and because it is possible for a police officer to stop a motor vehicle, Your Honors should find in the Commonwealth's favor.
Well, let me ask you about the authority to stop a motor vehicle. Is Chapter 90 such a comprehensive scheme that the authority of a police officer to stop a driver for a motor vehicle infraction only grants that police officer the authority to stop a motor vehicle for a motor vehicle civil infraction or criminal infraction?
Your Honor, I don't believe that Chapter 90, specifically Chapter 90C, Section 2, the no-fix statute, or Section 3, explicitly authorizes a police officer to stop a motor vehicle.
Well, Section 25 does.
Your Honor, we're dealing with language that's very similar to the no-fix statute in this case. The language we're dealing with in the case law is that upon the observance of a violation, the police officer shall have permission to stop the motor vehicle. Here, the statute, Chapter 40, Section 21D, directs the officer, if possible, to deliver a copy of the notice to the violator. So the only question is whether it's possible for the officer to deliver that by stopping the motor vehicle. I suggest it is. A contrary result creates a zone of exclusion in a motor vehicle in which individuals can consume marijuana with impunity.
Can we go back to the example of the motorist who runs a stop sign? That's pretty clear. The motorist has run the stop sign. The police can obviously stop the car and do whatever they need to do for that. But in this case, can we say that the police had that level of certainty about what was going on in the car? You know, are the two situations analogous there? Your brother says that there was only a suspicion that marijuana was being used, and that for that reason the police couldn't stop the car. What's your take on that?
Your Honor, Commonwealth v. Washington 459 Mass 32 articulates in footnote 14 that the standard for stopping a motor vehicle for a motor vehicle infraction is reasonable suspicion. The case law in general articulates it as an observed infraction because usually we're not dealing with a fungible question of whether there was an infraction or not that creates a need for further investigation. However, there are some examples in the case law. The Washington case cites an appeals court decision, Commonwealth v. Baez, B-A-E-Z. That case involves a window tint of the vehicle. The officer was permitted to stop the motor vehicle to conduct further investigation to confirm his initial reasonable suspicion that the vehicle's windows were in fact tinted beyond statutory provisions. Further, the Washington case itself deals with a seatbelt law violation. There was initially some question as to whether the seatbelt violation had occurred. So the standard I believe we're dealing with is the stop is permissible if there's reasonable suspicion for the officer to believe that the vehicle contains marijuana, and then the officer...
But that's only... you know, all the other examples have to do with something with the car itself. You know, the car having, you know, it's a moving violation, or the car has a window that has a tint that may be too dark, or that there's a stoplight that's out on the car, or something having to do with the car. The marijuana has nothing to do with the car. It's just a separate civil violation to have it. And I just wonder, I mean, would you extend this to, there are other civil violations too. For example, littering is probably subject to a fine. Now, if I throw a banana peel out of my window, can I be, while I'm driving, can I be stopped for that?
Your Honor, I believe that would constitute a criminal offense. So
throwing a banana peel out of the window is a civil offense, is a criminal offense?
Your Honor, the littering statute, as far as my research could determine, doesn't really articulate a volume of litter that's required before you can be charged with criminal littering. So I would suggest that's an inapposite
criminal offense to throw the banana peel out. Huh.
What about Justice Spina's example of the driver apparently drinking a bottle of beer? Is that a civil infraction? Open canister in a motor vehicle?
Your Honor, I would suggest it is. I don't know that that provides thorough guidance here because I was unable to find any case law.
No, just wondering. I mean, it may be that the officer thinks it's a Heineken or it's a green bottle, but it might have reasonable suspicion thereof, but not be, you can't confirm till you see the label, particularly brown bottles.
Well, Your Honor, I would suggest, again, the Washington case articulates the reasonable suspicion to conduct a motor vehicle stop for a civil infraction. So,
help me here. If this officer had made the stop for the purpose of making an arrest, illegal, correct?
I'm sorry, Your Honor?
If this officer had made the stop for the purpose of arresting him for the possession of marijuana, the stop's illegal, correct?
Yes, Your Honor.
If he had made the stop for the purpose of conducting any...
I beg your pardon, Your Honor. May I rephrase my answer? The arrest would be illegal, Your Honor, but the stop would still be permissible, the officer's subjective intent being irrelevant. Okay,
so basically what you're saying then is that if you are right, an officer can always stop a motor vehicle regardless of the officer's intent, even if the officer has no intent to issue a civil citation, because of this possibility that if that was his purpose, it would be legal.
I'm sorry, Your Honor. What was
If
the
you were
question?
right, basically, a police officer can always stop a motor vehicle based on reasonable suspicion that there is marijuana in the car, no matter what the amount.
Well, Your Honor, so long as there is reasonable suspicion, yes.
Okay. So basically, all of the restrictions that have been imposed with regard to the fact that it's decriminalized would go out the window.
Not at all, Your Honor.
Why is that?
Your Honor.
Because the stop, it's the same stop.
But, Your Honor, those decisions are dealing with searches of the vehicle. Those are probable cause and reasonable suspicion standards. We don't have reasonable suspicion for an exit order. We don't have probable cause for a search. We merely have reasonable suspicion of a civil infraction to stop the motor vehicle and issue a civil citation. The stop may go no further beyond that, absent additional circumstances justifying the officer in an exit order or reasonable or probable cause to search the vehicle under existing case law.
Where are you getting the reasonable suspicion standard for a motor vehicle stop? Is there a case that says that?
Your Honor, that's Commonwealth v. Washington, 459 Mass. 32.
I know you said that before, but I thought the statute said something about observing, the officer having observed the infraction.
Your Honor, that's to issue the citation. That's a different standard. That's a probable cause standard. Washington also articulates that. The initial stop itself, though, merely requires reasonable suspicion of the infraction.
So just to follow up on some of the other questions that have been asked, an officer reasonably suspecting that somebody in the car has marijuana can stop it and investigate? Is that your position?
Your Honor, the investigation, no. The only thing they can do is stop the car and issue a civil citation under Chapter 94C, Section 32L.
Based on reasonable suspicion.
If, Your Honor, they conclude there is probable cause at the time of the stop. They have reasonable suspicion to stop the vehicle for the infraction based on, in this case, the odor of marijuana emanating from it, and then probable cause to issue the citation when the driver confirms that the blunt in his hand is what the officer smelled emanating from his car. So the officer had probable cause to issue the citation in this case at the time he approached the driver, observed the marijuana cigar, the driver confirmed that was what the officer smelled.
Does it matter, though, when he stopped the car, that that was not the reason that he stopped it? He was, as your brother said, doing it in response to an order that had nothing to do with marijuana.
Your Honor, I believe in the past this court has found that the officer's subjective intent is irrelevant in these types of situations. What matters is whether the legal standard has been met, and therefore, if the court finds that reasonable suspicion to stop a motor vehicle upon observance of a civil infraction, as we permit under the motor vehicle type issues, is permissible, then yes.
So if the person were a pedestrian and the officer smelled marijuana, actually even smelled marijuana as he walked by, freshly exhaled marijuana, could the officer direct the person to stop and come and identify himself?
Your Honor, I think that the officer is entitled to issue a civil citation at that point, and that civil citation would require the officer to identify the person in order to particularize the violator on the citation.
So that there's an implicit authority to stop a pedestrian.
Yes, Your Honor. In the same way, I would suggest there's implicit authority to stop a motor vehicle.
Is it the same authority?
Yes, Your Honor. It comes from Chapter 40, Section 21D, which directs the enforcing person, if possible, to issue notice to the violator at the time and place of the violation.
So, okay.
Can't issue notice unless, of course, you know the name of the individual.
Yes, Your Honor.
So play this out for me. Police officer has reasonable suspicion or probable cause that a driver or passenger is smoking marijuana, stops the car, you say that's fine.
Yes, Your Honor.
Let's assume that for whatever reason he has concerns that one of them may be carrying a weapon. He can order them to exit and do a frisk of that individual end of the car?
Only if the standard of reasonable suspicion to believe the person has a weapon on their person, the same factors that we deal with in ordinary civil motor vehicle traffic stops, where we see a person making a furtive gesture.
Gonzalez.
Sorry.
Gonzalez. Commonwealth versus Gonzalez?
Yes, Your Honor. So only if those additional indicia exist at the time of the stop and there is no further investigation by the officer that exceeds the bounds of the mere issuance of the civil citation.
All right. So should we be concerned that this will vitiate the decriminalization of marijuana to the extent that it permits essentially the very same police conduct to investigate a civil violation as is now prohibited to investigate a criminal violation?
No, Your Honor, because it's not the same investigation. The investigation that a crime entails gives probable cause to search a vehicle or reasonable suspicion for an exit order. Those things are still verboten, if you will, absent additional factors that we already permit under the case law. This does not create an extension of the law. Officers already have permission to stop motor vehicles for civil infractions, and an investigation may pursue from there if additional factors exist, and that is all that would be permissible here. An officer may do nothing more than issue a civil citation for the marijuana violation. If there happens to be additional factors present, then I would suggest the police are entitled to follow up on those under existing case law, but they may do no more than issue the citation absent those factors.
And in this case, was a civil citation issued?
No, Your Honor.
So how can it be justified on the basis of a civil citation that was never issued?
Your Honor,
where that was not the intent anyway.
The individual in possession of the marijuana in this case was the driver. The defendant in this case is the backseat passenger. So that's sort of apart from relevance to this case particularly. This individual was not in possession of marijuana, so clearly she wouldn't have been charged civilly with the possession thereof.
But you're basically saying that this search is permissible because it is for the purpose of issuing a civil citation which was never issued.
Not the search.
Your Honor, there was no search here.
No, I know. It was a plain view. It was a plain view observation. I understand.
Yes, Your Honor.
But
the same way that if the officer had stopped...
But the so-called justification for this stop was a justification that was never acted upon by the officer.
The Commonwealth does not contest that, Your Honor. The issue here, I beg your pardon, under existing case law, my understanding is the subjective intent of the officer is irrelevant so long as the legal standard is met. Therefore, because the officer had reasonable suspicion of a civil infraction, he was entitled to stop the motor vehicle. The plain view observation followed with no further investigation by the officer.
If the marijuana is clearly being smoked by a passenger and not the driver, passenger who's sitting in the back, does the officer still have the authority to stop the car?
Yes, Your Honor, I would suggest that the officer has reasonable suspicion of a civil infraction being undertaken by an occupant of that motor vehicle, the same way that if an individual wasn't wearing their seatbelt, albeit not driving the car in a passenger seat, that individual would be a passenger in violation of a civil statute. And
you know, we have zoning laws that allow cities and towns to create certain fines for certain violations. And some towns have violations during election season of posting a sign on your lawn that's bigger than like 2.5 feet by 2 feet. So if somebody has an election sign that's 3 feet by 5 feet, walks out of their house and gets in their car and starts driving away, and could be a $50 fine. And a police officer sees the person doing this. Could the police officer stop the person from driving away so that he could issue a citation for violating the zoning ordinance?
Your Honor, provided that the officer's opportunity to issue that citation to the individual before they got in their car was non-existent or was the result of the individual's action. But the statute directs that the citation be issued, if possible, to the violator at the time. So if it's possible for the officer to stop the vehicle and issue the citation, then I suggest that Chapter 40, Section 21D allows that. This court has previously held in the Cruz case that an individual who parked in front of a fire hydrant, which I suggest is a municipal ordinance violation, the parties in that case, and this court noted in its decision that it was uncontested, that the individual was entitled to be stopped under that condition. The parking regulations, Your Honor, are authorized pursuant to Chapter 40, Section 22 So those are municipal ordinance violations, Your Honor. And so this court has previously held, because that vehicle was in violation of a municipal ordinance, that he may be stopped. Or at the very least noted in dicta, I beg your pardon.
Thank you, counsel.
Thank you, Your Honor.